Nō reira ngā iwi take o te whanganui a Tara, koutou ngā herenga waka, koutou kua hara haere tāwhiti mai, tēnā koutou, tēnā koe te mineta, kōrua tahi koto hoa mineta mete, kei te hara mai muri nei. Hoi no e huri, e mihi ana ki a tātou, kua tai mai, kua whakaropu tahi ki te kōrero i tēnei take nunui mo te ao Māori. Nō reira, kārea tōroa ngā mihi, tēnā koutou, kia ora mai tātou. Now, I have no visuals, I'm sorry. You have to look at me. I have a paper. I haven't finalised the paper, but it will be finalised before we leave today and will be available. The reason I did not finalise it was that I was a little unsure about one or two of the aspects of the policy matters that would be discussed today, and I just didn't want to say the wrong thing. And I'm also going to try and stick fairly closely to my paper. So forgive me that I read largely, but there are things that a judge needs to be careful he or she doesn't say. So that's why I stick to this. But I'm grateful to be invited to be here. And what I've been asked to talk about is the current review of the Act. I'll touch on that. I'm also going to speak briefly about the relevance of, or the ongoing relevance of some of the issues touched on in the Auditor General's 2011 report, which was known as the Government Planning and Support for Housing on Māori Land report, and the Productivity Commission's 2012 Housing Affordability in New Zealand report. I'm going to talk briefly about some of the lessons that I took from the Vancouver conference last year, the World Indigenous Housing Conference, but mostly I'm going to talk about some of the key challenges for housing on Māori land. I didn't give my talk the title, The Big Picture, and you can decide if it is a big picture or not. And before I go on, how much time do I have? Kei te pai? All right, if I can speak briefly about the review of the Act. My comments need to be limited for two reasons. In the first place, the review panel has yet to complete its task, and we simply do not know what the final recommendations may be. But secondly, and more importantly, it would be inappropriate for a member of the judiciary to comment publicly on possible government policy when policy is the prerogative of the executive. So what I will comment on is some of the issues that have arisen in the course of the review process. The objective of the review is to unlock the economic potential of Māori land, which is clearly a laudable objective. However, there is some disquiet amongst Māori landowners who fear that the review may force them to develop their land for commercial purposes. That is what I have perceived. Any such concerns should be misplaced. The publicity material accompanying the review has emphasised, just move those, that the intention of the review is to assist owner-driven utilisation of land rather than seeking to impose predetermined solutions, and that is how it should be. Our post-treaty history tells us that invariably it has been the aspirations of central and local government that have driven Māori land policy and not Māori themselves. But if we reflect on the numerous acts that have governed Māori land since 1840, Te Ture Whenua Māori Act 1993 has by far been the most successful in reflecting and articulating Māori values. And I would suggest it has been the most neutral in advocating particular uses of land. The Act's kaupapa, as we know, is the promotion of the retention, use, development and control of Māori land as taonga tuku iho by Māori owners, their whānau, their hapu and their descendants. And the review panel has made it clear that it will not be tampering with that kaupapa. Nevertheless, we, the court, the review panel and the government must guard against making unwitting value judgments as to what is the best use of Māori land. Māori communities are dynamic and diverse, and so too are their aspirations. Just what amounts to underperforming land is not as simple as some might suggest. To give an example, in my work in the Taitokerau district, I travel regularly to court sittings in Kaikohe, Kaitaia and Papakura in South Auckland. I routinely pass through communities where horses graze in paddocks, yet a generation or two ago there would have been a herd of dairy cows that supported a family. But the communities I refer to are not only rural Māori communities in Northland. They include the affluent, largely non-Māori community of Karaka, adjacent to Papakura, where lifestyle blocks are the norm, and where obviously horses are valued as much as they are in Northland. But my point is simply which land is underperforming, and who is the judge of that? Surely it must be the owners. The flip side of the value judgment coin is those Māori land blocks that are well utilised but the owners receive negligible benefits. For example, in the 1970s and 1980s, significant areas of marginal land were committed to plantation forestry. In the Taitokerau district, the first rotation of trees has been harvested in recent years. But owners are now being told that due to a number of factors, including the need to meet the cost of reforestation, they will not receive a dividend until a second rotation has been planted, grown and harvested. That is a wait of 50 to 60 years in total, 3 generations for a financial return. Understandably, there is a degree of scepticism amongst Māori landowners about the real benefits of optimal land utilisation. But whether it be grazing horses or growing trees, the real test of success is whether the owners have made informed decisions about their land. One of the more concerning aspects of the review process has been the level of misunderstanding and ignorance within the media and the non-Māori community about what the court does and what factors actually influence the underperformance of Māori land. Take the media, for example. A little over 2 weeks ago, the Te Manu Kōrehi program on national radio ran a story on the review that suggested that the Māori Land Court decided how Māori land was to be developed and used. The implication being that Māori landowners could not do anything without the approval of the court. This is patently incorrect, but it is difficult to correct this type of perception once it is in the media. The Māori Land Court does not sit as some grand arbiter of how Māori land should be used. As the kaupapa of the Act makes plain, the court is there to facilitate the aspirations of Māori landowners. Certainly the court has a key role in resolving disputes where owners cannot agree, or in putting in place appropriate governance structures, or in addressing poor governance, or in altering aspects of land ownership and titles where needed. But the court is not the gatekeeper of land development initiatives. One only has to look at the many success stories amongst ahuwhenua trusts and incorporations in recent years. They have not succeeded because the court has approved a particular development. Rather, they have succeeded because those in governance made sound decisions. In a similar vein, it is simply wrong to assume that the often low level of owner participation in land meetings is a significant cause of underperformance of Māori land. The reality is that for a number of years there have been low levels of owner participation. However, that has not prevented successful trusts and incorporations from developing their land. These blocks with large owner numbers, over 500 owners, do well if they get 10% of the owners at an AGM, and more often they get around 2 to 3% turnout. But they succeed regardless. As I go on to say, the key determinant of success of Māori land is the ability of those in governance. The then Ministry of Agriculture and Forestry's March 2011 report, Māori Agribusiness in New Zealand, a study of the Māori freehold land resource, commented to that effect, that the success of enterprise is strongly linked to the ability to make decisions and access to and availability of appropriate skills and capability. If I can now move to the recent reports on Māori housing, and I won't discuss this in great detail. I've made the main points in my paper, but as you'll be aware, we've had the Auditor General's 2011 report, and the Productivity Commission's 2012 report. The Auditor General's report identified several barriers to building houses on Māori land. Difficulty in raising finance, council planning restrictions, land rates arrears, the cost and delay in installing infrastructure, and the gaining of consents from owners of land in multiple ownership. The report made 5 general recommendations: better coordination between agencies involved in housing on Māori land, that local councils build appropriate flexibility into the district plans to accommodate Māori housing, that local councils work with landowners who have suitable land for housing, that the Department of Building and Housing, as it then was, better target financial support programs, and that the department work with other agencies to build the capacity of Māori organisations to plan to participate in housing. And I think it is encouraging to hear about the changes in some of those policies today, and to see examples of groups that are working closer with councils. The Productivity Commission's report discussed Māori housing in the context of housing affordability in general, and it touched on some of the significant, some of the issues in the Auditor General's report. The report provided some interesting discussion points for improving the financing and management of housing on Māori land. It was obviously intended to be innovative. One of the ideas, the mutual insurance scheme, is worth investigating. But as I commented in my paper in Vancouver, applying retirement village style licences to occupy, or the Unit Titles Act to Māori land, to the Māori land environment is unlikely to work, and there is a danger of reinventing the wheel when the Act already provides various tools to address the issues faced by Māori landowners. I understand that the Kāinga Whenua Loan Scheme and other government schemes have been revamped, and we've heard about that today, which is encouraging, and no doubt with anything such as a new policy of this nature, there will need to be close monitoring of how well it works in practice. If I can touch on the World Indigenous Housing Conference last year, and I was truly privileged to accompany the New Zealand delegation with our minister here to Vancouver, where I presented a paper, and I'd just like to share just a handful of the lessons for me from the conference. Overall, the conference demonstrated that notwithstanding the diversity of Indigenous peoples, there is a commonality of issues concerning housing. I've suggested that these stem from common tensions between collective and individual interests and aspirations, but that analysis may be too simplistic. Although governance was listed as a theme of the conference, it was in fact not given particular prominence. Nevertheless, the conference illustrated the significant diversity in legal and political structures across Native communities in North America. And for me, the conference reinforced that the trust model under our Act is a very flexible, efficient and effective governance model for Māori land. One interesting issue was that of home ownership, and again we've touched on that today. I had discussed this in my paper, and in particular the policy decision that owners and trustees need to make as to whether the houses are to be owned collectively, i.e. by the trust, or individually. And I suggested that for various reasons, few Māori land trusts have been able to be successful landlords, and that otherwise, invariably, Māori landowners do wish to own their homes themselves. That's at least my experience. And so that issue of home ownership came up in the context of the conference. We had the very charismatic Chief Clarence Louis of the Osoyous Indian band, who promoted home ownership as part of self-determination and the unshackling of Indigenous peoples from welfare dependency, as he put it. We had Habitat from Humanity, who also promoted the individual and societal benefits of home ownership. But on the other hand, the realities of many Indigenous communities, particularly those in urban centres, is that home ownership is neither affordable nor achievable. Thus, the conference reinforced that social housing is a permanent feature of Indigenous communities, but that many communities strive for and are able to achieve individual home ownership. And again, it's encouraging to hear Victoria talk about Mangatawa Papamoa Incorporation looking to provide both social housing in the sense of housing that the incorporation owns and rents to, or maybe via Housing New Zealand, but rents to beneficiaries, and otherwise for beneficial owners to actually own houses themselves. Finance was another issue discussed at the conference, and some of the interesting innovations were government guarantees. In Canada, they have an outfit known as the First Nations Market Housing Fund, which provides a 10% backstop by way of a guarantee of 10% of the home loan to private lenders. And in the USA, which is a special case, they have quite an intricate tax credit system which encourages private enterprise to support philanthropic purposes, including Indigenous housing, which was very difficult for me to fully understand, and so I won't explain it to you in detail. But can I move on to what I am mostly hoping to talk to you about, and those are the key challenges for housing on Māori land, and I've listed several. And once again, many have been covered to some degree thus far. The first is governance. The key determinant of the success of Māori land initiatives remains the skills and abilities of those in governance. Unfortunately, the consequences of poor governance have been reinforced by the Court of Appeal in the last week, and I'm referring to a decision concerning the Opepe Farm Trust. The importance of skilled governance is as true for housing as it is for commercial development. In fact, the challenges for trustees dealing with housing can be greater than for other trusts involved in commercial enterprise. Invariably, the land does not produce an income. The trustees are volunteers and they have no real access to professional advisors. Furthermore, unless the trust can afford a property manager, the trustees are often drawn into management issues such as collecting rent, ensuring that mortgage and other payments are made, attending to maintenance and repairs of houses and infrastructure, and addressing the numerous social issues that arise within a community. Developing housing on Māori land encounters a wide range of issues and therefore necessitates a broad skill set. It is no different to the challenges that face a developer of general land who will have on his or her payroll as a minimum a lawyer, a resource management specialist, an engineer, a surveyor and an architect. And it makes no difference that housing on Māori land is not for profit. The same hurdles need to be cleared. The court has an important function in ensuring that those who are appointed trustees have the right skills. But even for the most qualified trustees, professional advisors are needed. Government funding of professional advisors will go a long way to improving the success rate of housing initiatives on Māori land. And again, it's heartening to hear the extent to which that is available to promote projects. Finally, in terms of governance, there is room for better documentation of governance structures and tenure arrangements relating to housing on Māori land. And Victoria, I hope you've got your ears open. The court has revised its trust orders as best as it can, but there is a need for lawyers working in this field to develop more robust tools to address the complex issues that affect housing on Māori land. One only needs to consider the plethora of covenants commonplace in modern subdivisions of general land, or the body corporate rules that apply to unit titles to see that Māori housing could be better serviced. So there are things that can be done there. Can I talk about land use rights, which again has been discussed today? Māori landowners do not require the court sanction before they can build, and land blocks held by a small number of owners can often progress matters without any reference to the court. But, and there is a big but, where the land is in multiple ownership and individual owners require exclusive use rights, resort to the court may be necessary. There are three common approaches for securing exclusive use rights. First, the landowners or trust may grant a licence to occupy to an owner, which we've heard about. The court is not directly involved in this process. It became popular in the late 1970s and 1980s as it was used in conjunction with the government's housing programs. These tools are particularly appropriate today where occupation orders are not available. Licence to occupy remain the only option available if owners wish to take up the Kāinga Whenua loan scheme. But the licence to occupy does have its challenges. Its term is generally limited to 30 years. It generally does not allow for succession when occupiers die, which often leaves families in limbo, and we've seen that in our court with licences to occupy issued in the late 70s, early 80s, where the couple have passed on, and then there is a problem with them dealing with the house. It is curable, but it's just more involved. The documents themselves have barely been revised since they were first drafted in the late 1970s, at least that's my experience. And while they are termed licences to occupy, they are in most instances in the nature of leases, as they grant exclusive occupation, which may have other ramifications. The second approach is occupation orders. This was an innovation of Te Ture Whenua Māori Act 1993 and has been very successful. The major point of difference from the licence to occupy is that an order may go on indefinitely and may be succeeded to, and an owner's entitlement is dependent on the size of his or her interests or shares in the land. An occupation order is arguably a more robust form of tenure than a licence to occupy, as it is an interest in land. It is also recognised as a separate rating unit under the Local Government Rating Act 2002. But there are difficulties with the occupation order regime as currently drafted and implemented. For reasons that still remain unclear to me, the Kāinga Whenua loan scheme is not available in relation to occupation orders, and I thank Tom for the invitation to everyone to take up this issue. Second, the Act needs to be amended to enable conditions of occupation orders to be imposed, for example, requiring contribution to infrastructure costs, and not just the establishment of infrastructure, it's the maintenance over time, which is often a problem that comes up in our court. And third, the Act needs to be amended to enable occupation orders to be granted in favour of beneficiaries of whānau trusts, which at present is not possible. The third approach is that the court may partition house sections, but as has been observed, this is more difficult to achieve under the 1993 Act than under previous legislation, and the occupation order has generally replaced the need for partitions. Now, I'm not here to argue for or against the approach that the Act currently takes, but what I would say is that the part of the stemming of the tide of sales of Māori land has been as a result of the stopping of partitioning of land, because unfortunately the experience in the previous 20 or 30 or 40 years that there was often sections partitioned and someone quickly sold them. And that's an unfortunate truth of what has taken place in the past. But where a mortgage is required, partition may be necessary. For myself, I have promoted the idea of a hybrid partition as an alternative form of partition, and this involves subdivision of the land into sections. The owners retain their underlying ownership in all of the sections, but through the tools of trusts and occupation orders, individual owners have exclusive rights to particular sections. One further comment about partition orders is necessary. How many do we have here from local authorities? We've got 3, 4. All right. This is for you. It has been suggested by some councils that the court's partition and other title orders are not legal title and can be ignored. That is incorrect. The court's orders relating to titles must be registered with LINS, and that's sections 123 and 244, and are most certainly the basis of the LINS title. They cannot be ignored. Overall, the lesson in all of this is that landowners need to carefully decide which of these 3 approaches best suits their circumstances. And sometimes more than one approach will suit a land block. And if I can just expand on that, there will be times when a block will suit having both licenses to occupy and occupation orders. Occupation orders work very well where the owners have sufficient interest to justify an occupation order. And I use the example, if you've got a block with 10 owners and there are 10 house sites on the block, then each of those owners is going to qualify for an occupation order. But if you have a block where there are only 5 house sites but 100 owners, it's a more challenging prospect. With licenses to occupy, it's not directly linked to the ownership interest in the land. So it's horses for courses, and I think that the smart trusts and incorporations will have a suite of both. The next issue is home ownership, which I have already touched on. And as I've said, one of the key decisions for trusts is whether they should own the houses and rent them to the owners, or whether the owners should own them themselves. And the experience of the court is that land trusts that own houses and rent them to the owners only succeed where the trust has a robust governance structure and is financially sound. Can I emphasise the last, but it is hugely burdensome, as many of you will know, for trusts who are volunteers to not only put together a housing project, but then to be expected for the rest of their lives to be volunteer landlords. I think that has to be looked at realistically. Furthermore, it is doubtful whether building and renting out houses on Māori land is a prudent investment for those trusts. That's not to say that housing is not a proper part of a trust kaupapa, but it's not going to be an investment which returns financially. Infrastructure is one of what I see as one of the sleeping challenges for Māori housing. And again, I'm encouraged that the policy has been changed or improved to enable grants for infrastructure. Infrastructure such as for water reticulation, stormwater, sewerage and roading is critical for housing, but is often not addressed adequately. Now, it's straightforward enough for the court to make the orders necessary, but it is the contribution to the cost of construction and maintenance of the infrastructure which is a problem. How are we going for time, Patrick? I understand that the funding policy has changed. Just one other point in that regard, and that is that in my paper I delivered in Vancouver, I suggested that one option would be to look at the Māori trustee being used to manage what's known as a sinking fund to collect and retain monies for repairs and maintenance of infrastructure. Now, what that is a fund which is occupiers of the property. It's a small levy which is collected. It's part of their obligation. It's put away as a pūtea. It builds up and it's then used for doing up the road or what have you. And look, it's not only Māori that have to deal with this. If you go in and buy in an apartment block or in a gated subdivision or whatever the Pākehā community live in, or the general community, you'll be contributing to this sort of collective fund. And I've suggested that perhaps the Māori trustee could manage a fund like that. Finance is a challenge. We've talked about that, and I don't think I need to expand on that to any degree. But can I just make one point in that Māori land title is not deficient. Māori land titles can be mortgaged. The real block is that owners are quite reluctant to expose their land to mortgage default, and to answer the question that was raised at the back about the earth homes. The reality is that the funding structure, unless you're going to mortgage the land, the funding will only ever be over the house, and if it's to be over the house, the lender has to be able to pick it up and take it away if there is default. One of the points I made in my paper in Vancouver is that what is needed, what could be addressed better is what happens on default in terms of quickly ensuring that others within the ownership community are given the opportunity to buy the house before it's shipped off. Sharon Hawke asked the question about of Mike as to how often have houses been carted off land. I can tell you that in the north they have, but in more situations than not, other owners have stepped in, purchased the house of what is now Home Mortgage Company or part of Westpac. The final major point is that of council requirements. One of the most significant challenges for Māori landowners is navigating council land use and building consent processes, and this was a major point of the Auditor General's report. The Act provides some dispensation for Māori land from subdivision requirements of the RMA, but Māori landowners are nevertheless required to comply with the Council's land use and building consent requirements. So, under Section 301(1) of our Act and Section 11(2) of the RMA, the subdivision requirements in a district plan do not apply to a hapu partition. However, Section 9 of the RMA, which relates to restrictions on land use, still applies, and similarly under Section 3283 of the Act, although an occupation order is not deemed to be a partition, development or subdivision of land, Section 9 of the RMA still applies. All of this means that housing proposals that entail licences to occupy or occupation orders or partitions will still need to comply with the district plan's land use provisions and may well require resource consent. Furthermore, development contributions under the Local Government Act and financial charges under the RMA may still apply. And again, Victoria talked about negotiating the reduction of those. As far as district plans are concerned, councils take vastly different approaches to making provision for housing on Māori land. In the Taitokoro district, we have 3 territorial authorities, Far North, Whangarei, Kaipara. We have 1 regional council, that's the Northland Regional Council, and 1 unitary authority, the Auckland City Council. And in total, there are 12 separate operative district plans in the region. So quite a lot to get your head around. And one of the major issues, as you'll know, in rural areas is the residential intensity provisions. And in my paper, I summarise 3 different approaches, and I don't need to discuss those in detail with you, but the point is that the Far North District Council, Whangarei District Council and Kaipara District Council take 3 different approaches. And I'm not necessarily saying one is right and one is wrong, but they are different, and they take quite a bit to get your head around. The Whangarei District Council came up with what is known as Plan Change 95 in 2011, which was prepared with some consultation with the court. And so rather than having set numbers about a block in rural zone A can only have 1 house per 20 hectares, it doesn't provide that for Māori land. What it looks at is a case-by-case approach. And so what happens is a Papakainga development plan is prepared, having regard to the land's characteristics and the council's criteria, which sounds good, and it sounds like an improvement. The trick is that there's still quite a bit of work to be done to come up with that Papakainga development plan. And all in all, what that tells us is that you need professional advisors to assist in dealing with the council's requirements. Finally, can I conclude on this basis by saying that at the Vancouver conference I suggested that a think tank of some sort was needed to look at issues concerning Māori housing and ongoing issues. And some of the points that I think could be looked at are, and some of them are quite mundane, some of them are bigger picture matters. The redrafting of the standard licence to occupy, drafting standard governance and other legal conveyancing tools, investigating funding options including loan guarantees and mutual insurance schemes, exploring hybrid partitions as a means to enable the mortgaging of land in multiple ownership, amending the occupation order provisions in the Act and allowing owners with orders to qualify for the Kāinga Whenua loan scheme, and funding professional advisors to assist Māori landowners. And on that final point, can I just say that the previous presentation was very impressive, and I think even in the year since we were at the conference in Vancouver, you can see the expansion of the work that has been done. And I know she won't want me to sing her praises, but I think Victoria Kingi is a critical feature there. And I was talking just before to Do Hoskins about what it is that she's got, and the three things that he and I identified were skills, time, and passion. And I think that is quite critical, and what it would be nice to see is the replication of Victoria Kingi's skills around the country. Nō reira tātou mā, kua pau te hau o tēnei kaiwhakawā. Ngā mihi kia koutou, hākua te maroke o etahi o ngā kōrero. Kia kaha koutou, kia ora.